So we're fortunate that the CRTC published its interpretive guidelines very recently, so we're actually able to talk about them today. I understand that the CRTC might be publishing another set of interpretive guidelines early in 2013 as well. So the CRTC describes these as guidelines on the interpretation of the regulations and examples of what the CRTC considers to be compliant behavior. So they're not necessarily law, they're not necessarily legally enforceable, but this is a pretty clear message on how the CRTC intends to apply the Act. Being the primary enforcement agency under the legislation, they're always, in most cases, if we're not talking about the private right of action, but in most cases, they're going to be the first person who's actually considering whether a certain activity is a violation of the legislation or not. So in most cases, it would be wise to follow these guidelines. Now, there's always the possibility that if the CRTC comes to a finding on a certain issue that it results in a contravention of the legislation, we have the ability to appeal to the Federal Court of Appeal. So there's always the possibility that the Federal Court of Appeal could take a different view on some of these issues. But obviously, we don't, it's probably not wise to flagrantly violate the legislation on the assumption that we're going to be able to appeal to the court and change the CRTC's mind. So in no particular order, going through some of the issues that are addressed in the interpretive guidelines, one of the issues that's created, I think, the most confusion and the most questions, particularly for service providers, is what is meant in the legislation when they talk about sending on behalf of another person. And again, we look at the identification requirements. We have to identify who's sending and on whose behalf the message is sent. A lot of questions around whether this includes service providers, ESPs, agencies, whether it's intended to address a list rental or newsletter type scenario, so when I'm sending somebody else's content on their behalf to my own subscribers, whether it captures both. And the CRTC, fortunately, I think came to a pretty common sense resolution on this and some useful guidance. Again, there were comments on this issue following the CRTC regulations. So the CRTC has said that any person who may facilitate the distribution of a commercial electronic message, but who has no role in its content or choice of the recipients need not be identified. In my view, I think that's a pretty reasonable approach. I think it's pretty flexible. And I think it's reasonably clear that that means that ESPs do not have to be identified in every message. And I think that's a really, really important issue. It's obviously one that concerns a lot of service providers and a lot of their clients who don't necessarily want this information in every message. And it's also not particularly useful for consumers to be bombarded with all of this information. It's important to point out that this issue is separate from issues of liability. So if we're talking about liability of service providers for the actions of their clients, or vice versa, liability of a client for the actions of their service providers, those are separate issues. Those are important issues, and we can talk about them if anyone has any questions. But that's not addressed here. Really, this is only really relevant when we're talking about the identification requirements. Probably the second most common question, or possibly the most common question under CASL, is what does express consent mean? And every time I've ever talked about CASL, I've had at least one person ask, does this mean that boxes can't be pre-checked? I've always said, I don't know. I hope. I've always hoped that the CRTC wouldn't be too prescriptive on this issue. They have come down and are actually very prescriptive. They've taken the view that express consent must be opt-in, so we can't have any opt-out. In other words, boxes cannot be pre-checked. And I think it's useful to think a little bit about what consent means. So we always hear terms like express consent, implied consent, opt-in consent, opt-out. It's useful to look at express consent, opt-in and opt-out as two forms of express consent. When we look at the last decade or so of experience under federal privacy legislation in Canada, our privacy commissioner has always said that opt-out consent is okay for marketing purposes as long as certain conditions are met. Now the CRTC has said that it has to be opt-in, so boxes can never be pre-checked. So this is a fairly significant departure from what we've traditionally seen under Canadian privacy legislation, a much more prescriptive and stringent approach that's more in line with the EU approach on this issue. That being said, even though boxes can't be pre-checked, if we have a separate box that's specifically required for an individual to enter their email address in order to sign up for a list, i.e. we don't already have their email address for some other purpose, we don't have to have a separate checkbox. So the very act of writing or filling in your email address is significant enough to, as evidence of express consent. The CRTC has also said that we are required to send confirmation messages whenever we actually obtain express consent. So this is effectively a form of notified opt-in consent. Yes?
In the case where somebody's entering their email address to sign up for a service, would that be considered consent if, as part of that service, they were to be receiving email newsletters, et cetera, that may be considered separate from the service?
I'd have to say that depends, but based on what you described, probably not. So the question is, if we already are required to fill in our email address for some other reason, do we then have to have a separate checkbox? And based on what the CRTC is saying, most likely, yes. So if we're on a web page and at the top we're filling in our account information, which includes our email address, then we get to the bottom and it says, oh, you are also subscribing to this newsletter. Based on what the CRTC has said here, we probably need a separate checkbox that's not pre-checked at the bottom of that form. The CRTC provided some graphic examples of what is and is not acceptable. So here we see the box next to the consent statement that's not pre-checked, so this is acceptable. The box is pre-checked, not acceptable. Again, it's actually kind of hard to see, but next to the submit button, there's a little field where the user is required to enter their email address. So we have that specific consent statement right next to the field where we're required to enter email address and then click on submit. The CRTC has said that this is acceptable. So with that in mind, in some cases it might even be useful, even if we already have the email address, to have the individual enter the email address again, make sure that we have the right email address. And I don't know what the evidence is on this issue, but I know that in terms of what the default is on a checkbox, it makes a huge difference in terms of subscription rates. So I don't know if individuals might be more likely to fill in their email address than they would be to check an unchecked box, because in a lot of cases I think people are used to just clicking submit on a page and not having to check that extra box. So a confirmation message is also required. This is just an example that I came up with. So anytime someone has provided express consent to receiving a commercial electronic message, we then have to follow up and tell the individual that they've just consented to receiving a commercial electronic message. Again, this is a very prescriptive approach. This is the type of thing that might make sense in some circumstances. A lot of companies already do notified opt-in or even double opt-in. There are other cases where this would not make as much sense. For example, in a small business context, or if I'm just speaking with somebody orally after the seminar, and then you tell me that you'd like to sign up for a newsletter or hear a little bit more about my services, I would then have to go back to my office and email you first and tell you that you gave me oral consent before I would actually be able to send you a commercial electronic message. So when we look at how some of these rules apply in a small business context, or really outside of the mass emailing context that we really know here, a lot of these rules don't really make as much sense. So consent obtained orally, this is one of the issues that I think the CRTC is likely to hear the most about from a lot of industry stakeholders. The initial draft of the CRTC regulations that we saw last year did not allow consent to be obtained orally or verbally. That was changed. Obviously, there were a lot of comments about that. The CRTC has said that you can obtain consent orally. The issue that comes up with oral consent, though, is with respect to the burden of proof. So CASL says right in the legislation that anyone claiming to have express consent bears the burden of proving it. So then we get into issues of what is an appropriate form of evidence. So we have things like databases with time and date stamps screenshots of web pages that are used to sign up. We might even have things written down on forms that are used at point of sale. So we have to keep copies of those forms. Instead of being intentionally vague on this issue, the CRTC has come down and been very prescriptive and said that it would consider two forms of evidence acceptable for the purposes of proving that you have oral consent to send a commercial electronic message. So one is verification by an independent third party. We don't really know what that means. They don't clarify that, but it kind of seems to suggest that if you're talking to someone else at a reception, you need to bring in a third party who is able to verify or maybe swear a statement giving evidence that consent was actually properly collected in that circumstance, or a complete and unedited audio recording. And again, this might be practical in some circumstances where we're already recording conversations for quality control purposes. We've all heard that before. But to actually have to implement a system in order to obtain express consent over the phone is quite onerous. And also, we would have to keep records of that conversation, so we have potential privacy issues that are raised when we're retaining complete and unedited audio recordings of telephone conversations for potentially years and years. So not an ideal approach to verbal consent. Really, at the end of the day, this makes it practically impossible in a lot of circumstances. So I think anyone who might have been asking for consent at point of sale would be wise to switch over to actually having somebody fill out a paper form. And what you do over the phone, unless you already have a recording system set up, it definitely creates a challenge. I think the CRTC might be hearing from some people on this issue. Consent obtained in writing, so the CRTC has come out and said that in writing also includes electronic, in case that wasn't clear before. So this includes a checkbox on a website where a record of the date, the time, the purpose, and manner of consent is stored in a database. Also includes filling out a paper form at the point of sale. We need separate consent for separate acts, and really what this gets to is if we're asking for consent to install a computer program, we also want consent to send a commercial electronic message. They have to be set out separately. So I can't require somebody to consent to receiving a commercial electronic message as a condition of installing my computer program. A request for consent has to be separate from general terms of use. This is probably only really relevant when we're talking about the installation of computer programs. So if you're offering some sort of service, it could even be a web-based service, you cannot require someone to install your computer program unless it's necessary for the purposes of providing that service. And this is sort of a form of refusal to deal clause that we see in privacy legislation, which generally says that you can't require somebody to consent to the collection, use, or disclosure of their personal information unless it's actually necessary for providing the service. Even if the computer program is necessary, so it's necessary for them to download and install your app in order to use your web-based service, you still need a separate consent button or checkbox. And we need a separate checkbox for every single request for consent. We also need separate checkboxes for each of the specified functions. So if our computer program is performing more than one of the specified functions, we still need a separate checkbox for every single one of those functions. We can't have one for the whole group of functions. This is the example that the CRTC gives of what is acceptable. So we have the general terms and conditions at the top. We have a separate checkbox for agreeing to install the computer program. We have a separate checkbox for agreeing to receive CEMs. Question there?
What happens in the case where to install the product, there is interdependencies between these specified functions? In other words, if they do not agree to all of the specified functions, the application itself, or any number or combination of, if they don't have that magic combination, it becomes useless or it's uninstallable.
I think what the guidelines suggest is that you still need them to click all those separate boxes, but you can tell them, look, if you don't click all these boxes, you won't have access to the service. So you need to click every single box. This raises some challenges, and the rules that apply to the installation of computer programs, I think, raise some challenges in general for app developers, because from what I've seen, I don't think that anyone, please correct me if I'm wrong, that the major app platforms allow for this degree of granularity. You know, it's pretty much take it or leave it. You put a general description of what the app is, then you scroll to the bottom, or even right at the top, you just click download. Then the app is downloaded and installed, and then after it's installed, you're able to see the general terms of use. So there are definitely, I think, some challenges here that need to be worked out, and I think that the app platforms are going to need to think about how they provide this degree of granularity for app developers. Is there a question over there?
Yeah, I had actually a couple of questions, but
Sure.
Now that we're talking about that, maybe it's the right place. In Europe, and in particular in Germany, you sometimes have or had the problem that many people are co-sponsoring a certain consent people try to obtain. You have, for example, like 50 parties or more that are requesting consent. You have one sweepstake, for example, and you have to have one declaration and one box with which you can actually declare consent, and you have like 20, 30, 40, 50, or even more parties that are obtaining the consent. And there's case law in Germany, for example, in other European countries, that's restricting the number of parties that you can actually give consent to. So if I understand it right, in Canada that wouldn't be possible because you have to click for each recipient of the declaration of consent a separate box. Is that correct?
That's a good question. So the law does allow you to, if I understand the question correctly, if you're using a sort of co-registration page or you're obtaining consent on behalf of several parties at one time, do you need a separate checkbox for every party? And the guidelines actually don't say anything about that particular issue, surprisingly. The law itself says that you can obtain consent on behalf of another person as long as certain requirements are met. Most importantly, we have to identify who those persons are. There's nothing in the Act that I'm aware of that would specifically require a separate consent. As long as they're identified, you could have that sort of wholesale batch consent to all of those parties at one single time. Correct me if I'm wrong, but I'm not aware of any rule that would actually require separate checkboxes.
The issue with the co-registration actually was that the consent was not expressly given then, because people do not realize actually to how many parties they're giving consent, and if you have a list of 100 companies,
Sure.
then you don't actually expressly give the consent to this particular company. And if you click a box, maybe it's a different
Yeah.
situation, but nobody will go down a list, and you know there will be a fight who's on top of the list because you lose actually your energy after the 10th or the 20th recipient to go down the list.
For sure, a way for the regulators to potentially deal with this is really going back to the flexibility in terms of whether an individual actually, whether we could say that consent was properly obtained, whether it was clearly described. And in that circumstance, they might just come to a conclusion that regardless of the fact that we listed all these parties, there's so many of these parties that it's effectively meaningful, and we can't say that the individual has effectively consented to receiving communications from all of those parties. That might be one approach for regulators to deal with that.
It might become case law in Canada too.
Sure. And there's also the issue of, you often see, I agree to hear about deals from this company as well as our partners, our affiliates. And the law actually has specific rules that apply to identifying currently unknown third parties, because if you have a newsletter, you don't know who's going to be included in your newsletter 5 years down the road.
Yeah, but the question is who's getting your information, your personal data? I mean, there might be many people advertising that newsletter, but only one company that's actually keeping your data. And if you co-opt, for example, there are 50 parties that
Sure.
are keeping your data, and it's out there.
Sure, no, that's a good point too. If you're actually sharing the data with other parties, that's a separate issue from whether you're sending on their behalf. So yeah. if you're actually providing the email addresses to those other third parties, then there's probably a heightened sense of requirements and knowledge and consent on behalf of the user.
Thanks.
Any other questions?
Shaun, I had a question for
Sure.
you. I think the original published regulations had provided for a 2-year window during which the sender of the commercial electronic message was required to attempt to convert that implicit consent into explicit consent. Has that language survived in the current version of the legislation?
Yes. So the first draft was actually 18 months. So this speaks to the period for an existing business and non-business relationship under the implied consent provisions. So initially it said that if a recipient has made a purchase within the past 18 months, you have implied consent to then contact them. That was actually extended to 24 months. So that really should be looked at as a period to try to convert them from implied to express consent. There's also a transitional provision, which is very, very broad, which says that if you have an existing business relationship or non-business relationship, as of the date that the law comes into force, without regard for those periods. So practically speaking, an individual might not have made a purchase for 3 or 4 years, but as long as you've had some form of electronic communication with that individual, you have a transitional period which says that consent is then implied for a period of 3 years following the coming into force of the legislation. That's a very, very broad transitional provision.
So when does that clock then start? When you collect or when you first send?
It would be as soon as the law comes into force, effectively. And it would go for 3 years, obviously, unless someone has unsubscribed. A question in the back? Hey, Dennis, you want to pass over the mic there? Nice.
So in the transition from implied to express, must we get implied or express consent within that 3-year period? Is that mandatory, or I'm trying to understand that transition, how that's going to come into effect?
It's basically they're two separate things. So implied consent lasts, for example, depending on the circumstances, 24 months or 36 months. So you have that amount of time to send a commercial electronic message without obtaining express consent. Once that period expires, you no longer have consent. So then you can use that period as an opportunity to actually send an electronic message asking for consent. Outside of that period, you can no longer send an email asking for their express consent. Once they actually provide express consent, that never expires unless they unsubscribe.
Right, but you do have to, if you don't ask them for express consent after that period has expired, you cannot email them.
Correct.
Okay.
Correct. Another question over there.
From a practical point of view, there are quite a lot of violations, and the purpose of the legislation is to guide people into the right actions as opposed to being penal. But as long as there is an unsubscribe button, users are probably going to find it and click on it. What about all the mass mailings that are coming from criminal organizations, for example, that have no interest in even getting anywhere near this legislation? How's this going to even affect them?
I'll let Andre expand on that, but sure there's a fairly common view out there that the legislation might not be very effective in going after criminal organizations, say in Europe or elsewhere overseas. Andre, do you want to expand on that?
Yeah, there's a number of mechanisms within the actual legislation that will allow the 3 enforcement agencies to collaborate with their counterparts, be they in Russia or Europe or in China, etc. They just have to enter into an arrangement that they're going to collaborate in an investigation and go for it. The issue with an administrative law enforcement group in Canada trying to serve a notice of violation to somebody overseas is that, well, it won't be given effect. Which brings me to the private right of action. You can have an entity in Canada sue a foreign spammer, have the finding decided in the Canadian court system, and then have that finding, or at least try to have that finding, exercised in the foreign jurisdiction. So we have some examples of this where people were tried and found guilty under CAN spam, and they brought, so Facebook had one against Guerbez, and tried to have that finding upheld in Quebec Superior Court in Canada. and they found in favor of Facebook and upheld the California court decision in Canada. Well, the same will hold true for Canadian findings in most circumstances when we try to have those findings upheld outside of Canada. So we can go after, and Guerbez was a kind of a particularly malicious type of spammer, scammer, operating out of Canada. We still have some evidence that there's, some Canadian entities operating out there, but it'll also allow the Canadian court system to have those findings exercised in foreign jurisdictions. And actually, we asked Shaun to do an analysis report, a legal analysis on, are these Canadian findings going to be upheld in foreign courts, like in Brazil or India or wherever these guys might be hiding? And for the most part, the rule is that yes, because they want their findings upheld in Canada, they will uphold the Canadian findings in those foreign jurisdictions.
Thank you.
So my question relates to email consent and social media. So for example, there's a lot of websites right now that allow you to log in using, say for example, your Facebook account. I've seen situations where if I log in with my Facebook account to a certain site, I don't necessarily get any options for any sort of opt-in, even though I will, after signing in, I'll all of a sudden start getting messages from that site. So to that question, if for companies that are going to use third-party opt-in systems like Facebook, are they going to have to allow to meet this express consent requirement? Are they going to have to require someone to go through a maze of checkbox before they can actually log in?
Based on what you're describing, yes. I don't think you could just opt somebody in by you having logged in to a site using your Facebook account. They would need a checkbox or some sort of language just telling you that you're opting in and then giving you the option. Now, in a lot of circumstances, based on what the CRTC has said, you're going to have to be able to choose whether you want to receive commercial electronic messages, regardless of whether you're signing into the page or not. So you have to be able to sign into the page and then choose separately. So it can't be a condition of signing up for that service.
If you're a sender and you're sending a newsletter out, and now this sender decides to create a new newsletter, can they send it to the people that opted in to newsletter A, and now they've created newsletter B?
That would probably depend on the circumstances. It would depend on the nature of consent. So what did they originally consent to? Did they consent to receiving a very specific type of newsletter about a specific type of product? Are we talking about different subsidiaries of the same organization? If it's sort of a broad consent that said, I would like to hear about information about company-wise products and services, and you're just offering a different newsletter that does that, that fits within that original umbrella of consent, then likely in those circumstances you would be able to develop another newsletter. Now, there are other non-legal factors in there too, based on the expectations of the recipient. Is this going to surprise them? How different is it? Are they still going to be able to identify it with the same brand? But really, it depends on the circumstances and what they originally consented to.
And another question, you talked about you cannot pre-pop the checkboxes on, but that would not apply to anything like a preference page where you display for the recipient, you're currently receiving this, this, and this, and then the checkboxes are blank for the ones they're not receiving. Correct?
CRTC hasn't said anything specifically about that issue. I don't see anything that jumps out at me about that being inherently wrong, but we could talk about that a little bit more detail offline.
Okay, thank you.
For greater clarity, with regards to a long-term established relationship, is there any room or is there any provision in the regs with regards to long-term grandfathering? In other words, I know you talk about this sort of the up to the 3-year period for established relationships and so forth. Do you specifically have to renew that relationship or the consent portion of that relationship in that 3-year period, or is it grandfathered in? In other words, you've been dealing with this guy for 10 years, he's been sending you the stuff, it's been a happy relationship. Do you have to somehow throw some, stuff into the span works of that?
This is a big problem for every company out there. So what do we do with legacy data and these databases that we're not really sure about? So outside of that transitional period, really, yes, you're probably going to need to renew consent in some way. There was talk about trying to come up with some sort of regulation that would sort of grandfather in legacy data. So if we had some form, even if we had already had express consent, and we might have some form of evidence, what happens where that express consent doesn't conform to the specific requirements of CASL? Do we then need to go out and get new consent? And a strict reading of the legislation would probably say, yes, once the law comes into force, we need express consent, which conforms to the specific requirements of CASL. So even if you've been sending to these people for 10, well, probably not 20 years, email's only been around for so long, but if they're expecting it, that they like what you're sending, in a lot of cases, companies are going to need to send some sort of reconfirmation message and try to encourage people to opt in, provide express consent. So we really have that solid evidence that we could use if there's ever an investigation under CASL. That's the lowest, probably the approach that has the least risk.
One last question,
Sure.
with regards to that. Certainly in today's environment, there's a lot more tools that are available to make the determination as to the locality of a subscriber. And effectively, you can make that determination with a little bit of digging now. So if we're talking about truly international things such as newsletters and so on that are put out on an international front, coming out of the States and they're being subscribed to by Canadians or coming out of anywhere, that's going to be a bit of a hassle for these clients or these providers to make the determination as to the locality, the exact locality of somebody. And how does the legislation allow for that sort of flexibility? Because there's going to be honest mistakes. I thought that guy was from Canada, or I thought that guy was from the States, but he's actually from Canada.
It's a big issue for a lot of my clients and a lot of organizations, but Andre sort of has I think a canned response to this.
Two things. If you have express consent ahead of the coming into force of the legislation, ultimately, although I'm not allowed to interpret, you're probably on side. Again, it depends on the circumstances of how you collected the original express consent. Were you very clear? Did you keep a record? Were you clear that you were going to be sending commercial electronic messages or commercial messaging to them? That type of stuff. So it becomes circumstantial. It's a risk assessment by the enterprise, basically, to say, well, we've got a really good record. We send out to 150,000 people and we've got a really good record. Then, you may not need to be as concerned as if you were, we got these addresses from about 8 different areas in 8 different ways, and, some of them might have been less clear about what we're sending. So for that, it becomes a risk assessment. The other thing that you have to keep in mind, and I mentioned it earlier, is the factors to be considered. If you're going to find yourself in terms of the defense side of a private right of action or on the wrong side of a notice of violation, keep in mind that the law is not meant to be penal, and that there are factors that the CRTC and any judge has to take into consideration. And if you're not doing this for nefarious purposes, and the laundry list is in Section 20 of the Act, but there's a lot of things that come into account, and then the last thing is they have to take everything into account. So, if you made $6 million through the sending of the messages, then you can likely expect somewhere in that ballpark in terms of a penalty. But if you're just simply providing information, maybe not. So the courts will come up with those assessments. The international aspects is kind of tricky, but the key point here is that for everybody almost outside of the United States, their regimes are opt-in already. If you're looking to the EU, to the UK, Australia, Japan, our major trading partners, New Zealand, those major English-speaking countries that we deal with so much, they're already opt-in. So if you've got an international list, you've already got this issue. And you probably already have taken those steps. Good?
I think just to follow up on that, it's definitely an issue that a lot of people are trying to deal with. There are a number of factors involved. The number of subscribers who might be located in Canada, the degree of likelihood that you think you're able to clarify between who is in Canada and who isn't, the basis of your relationships, the likelihood that they're going to complain, what sort of commercial presence do you actually have in Canada, a lot of issues. But we can talk about this one a little bit more offline.
Hi. I see a lot of scammers lifting legitimate opt-outs from other sites. Is there an additional penalty for forging an opt-out link?
Possibly under the Competition Act, there might be some false and misleading, but at the end of the day, if you're using those electronic addresses without consent, the CRTC has ample power. You don't really need to have committed more than one violation under the legislation in order to be hit with a huge penalty. So in theory, the CRTC could fine that spammer $10 million for every single message they sent to one of those electronic addresses without consent. So I just have a couple more issues to cover under the guidelines, and I'll pass it over to Andre. So one of the other issues that the CRTC looked at under the unsubscribe mechanism is they come right out and said that landing pages are acceptable for anyone who wasn't clear on that. So we're allowed to use a link out to an opt-out page. They've said that explicitly. When we're talking about SMS, we have to provide the option between either replying with stop or unsubscribe, or having the link. So we have to have both the reply, stop or unsubscribe, as well as a link. I believe there was an example of that. So this is an example of an acceptable landing opt-out page that was given by the CRTC. So we have a choice between what we're unsubscribing from. And finally, the CRTC defined what a mailing address is. It includes a valid current street or civic address, postal box address, rural route address, or general delivery address. So unless there are any other questions on that component, I'm going to hand it over to Andre, who's going to cover the Industry Canada regs.